Welcome, everybody. I'm Fiona DiDomenico, Regional President with the Castle Group. Thank you so much for being here. And I have the honor today of being with Robin and Scott from Becker, who are going to give us a phenomenal presentation on covering your assets as a board member. So we're looking forward to having some fun today. For those of you that are not familiar with Castle, Castle is a Florida-based firm. We have over 300 associations that we work with across the state of Florida, so lots of offices throughout the state. And we're a little unique in that we specialize in communities where we can put staff on site. So many of our associations would have, they might be large-scale HOAs or towers where there's a team on site. A lot of our associations are highly amenitized with full food and beverage, full lifestyle divisions. So we've got lots of expertise in every area, and we would love to help you out. So our door is always open, and feel free to reach out. So thanks again for being here, and I'm going to turn it over to Robin. Robin, if you'd like to introduce yourself, and we're looking forward to today. So thanks for being here.
Hello, everyone. Thank you for coming to, well, I guess, watching today's webinar, where Scott and I are going to be talking about avoiding board member liability. Scott and I are both shareholders at the firm of Becker, which I've seen some familiar names attending today. So some of you may be familiar with us, but those of you who are not, we are a statewide firm. We initially started out providing community association advice to community associations across the state, and we've since expanded. We are a full service law firm, which means that we provide basically any type of legal advice that a community association or other type of client would need. We do have the most board certified attorneys at our law firm in community association law, construction defects law. I am board certified in community association law, and Scott is board certified in construction defects. We also have board certifications in civil trial law as well as real estate. And so we are going to be talking about board member liability. I'm going to shift it over to Scott today to start out with. And if you have any questions, feel free to, I think we'll have a Q&A at the end. I also appreciate your questions that you submitted at the beginning. Hopefully we'll hit everything, but if not, you'll have a chance to ask them at the end. So thank you.
Thanks, Robin. I hope everyone can hear me. Again, my name is Scott Kiernan. I've been with Becker for, it feels like 100 years, but it's great. I love it. I feel like when you're hiring our firm, you're not just getting the experience of one lawyer. We get to rely on the sound advice of lawyers going back from 1972, and we have 100 different lawyers that we can, 150 actually, that we can shoot an email to and get a litany of answers. So it's kind of nice that there's probably not an issue that we haven't seen and haven't analyzed at some point. So it's really great doing community association at our firm. I'm easy to find. I'm on the website. My email's there. I think I even have my cell phone number on the signature block of my email. So, if you have a question after today, feel free to get in touch with me very easily. Or, even if we don't represent you and you say, hey, I got a meeting tonight, what's your opinion on X? I can hypothetically give you some sort of general guidance. But I'm a litigator that's predominantly the majority of the work that I do. My passion is construction. And so I do love construction law and the construction defect components of it. I love getting associations money that they deserve for their buildings. But in litigation, that eats up the other part of my work. It seems like every lawsuit, everything I have is a lawsuit. But my job and Robin's job is to keep you out of litigation, to keep the association and its directors from any liability or from having its assets attacked. We want to get you out of it as quick as we can. Believe it or not, that's really, we don't have any interest in protracted and long litigation. That's not going to make anyone happy. So the goal is to try to get it over to your insurance carrier, get an attorney on board, get some type of redress for you quickly, and minimize your risk and exposure. And traditionally, you really shouldn't be in litigation. Associations have a lot of protections, and we'll cover some of those right now. Again, fiduciary duty, if we could just start with that one right there. You see on the slide the definition of fiduciary duty, duty of utmost good faith, trust, confidence. The way I like to define this duty is there is no higher duty. It would be the duty that you give your spouse. Okay, it's the shared type of confidence and protection that you would give a family member, that a lawyer would give to a client. There is no higher duty than a fiduciary duty. And that is, I mean, I know that seems daunting, like, wow, why does a director have to give a fiduciary duty? That seems like a high duty to an owner. But that's the duty that the Florida legislature has established that you have to give, unfortunately, to the owners in the association. So, and it's just, it would be to act in the best interests, whatever you can do to be as loyal and as, oh gosh, I can't even think of a stronger term, but it's the highest degree of honesty that you can give a person. So it's a pretty tough standard. And that's the fiduciary duty. So again, it's defined also in the Condominium Act. 718 is the Condominium Act. Most of you out there probably know that. 720 is the Homeowners Act. That's the statute for the homeowners. But it says right there, the officers and directors of the association have a fiduciary duty to the unit owner. And then 617 is the Non-for-Profit Act. And every association in Florida is a non-for-profit association. You don't pay shareholders with the money at the end of the year. It just rolls over into the next year for that budget. So you're a non-for-profit community. All HOAs and condos are like that. And it says that a director in 617 has to essentially discharge their duties in good faith with the care that an ordinary prudent person would give in a like position or in the best interest of the corporation. So again, this isn't really rocket science, it's just pretty common sense sort of stuff here. 718 goes on to say that you're not going to be individually liable. An officer or a director, you're serving these communities without being paid. I mean, it's a lot of work, as you know, or as your directors and officers know, and it's a thankless job because you're going to be the crazy unit owners are going to criticize everything you do, but you're not going to be held individually liable for the decisions that you make, unless, and this is defined here in 718.111, unless you as a director, again, and I feel like this stuff is common sense, unless you violate criminal law. You commit a crime for your association, I'm sorry, you're going to be sued individually. So if you create a transaction, okay, if you're an officer or director and you have a transaction where you derive a direct personal benefit, okay, and again, that's the thing I try to tell these directors and officers when they get on the board. Okay, yes, you're a unit owner, but now you have to actually take it a little bit higher. You owe a fiduciary duty to the members. So your duty now is heightened. You are no longer a unit owner on the board. You are a director that has a fiduciary duty. And so you're not supposed to get on there and enter into contracts where you get kickbacks or not make yourself pay assessments. I mean, these are direct benefits that you're going to get, and they're improper and they're obvious. You shouldn't do that. So you're going to be held individually liable if you get on the board and start funneling money to yourself. And again, if you engage in recklessness or in just bad faith, malicious purpose, you can see these are pretty extraordinary terms here. Wanton and willful disregard for the rights, safety, and property of the community, you can be held individually liable for that. So okay. So then we're going to talk about the business judgment rule. I love the business judgment rule because it's a rule that's been codified in the non-for-profit statute. So there's an actual statute on it. And it's a rule that I get to argue in court is, Judge, you don't get to second guess the decision that these directors engaged in. They did it with, under the business judgment rule, and it's not fodder for the court to overturn that or to supplant its own judgment for that. And a lot of times the judges are on board with that. They're like, yeah, I'm not going to get into the understandings or what went on how they arrived at a decision to pass a motion. They did that with their own business judgment, and it's not for the courts to disturb. And what the business judgment rule says is that if you discharge your duties, these directors discharge their duties based on the information they have at the meetings, the opinions maybe of some of their vendors, whether it be the lawyer, the accountant, even the landscaper, the reports, the statements that they have, the financial statements. If they use that information and rely on that to come to their decisions and a vote for the association, then that's sound business judgment. It won't be disturbed by the courts. Robin, let's go back to that real quick, if you don't mind. I hope not to. I don't want to eat up into your time too much either. So let me try to go as quick as I can. So again, it just means if you believe and you rely on competent matters, you're relying on your legal counsel's opinion, and if you reasonably believe that the committee's giving you the proper background, then you can rely on your business judgment. I don't want to beat a dead horse, but generally, if you're making decisions that are sound and based on the experts' opinions that your association employs, then you can't be held liable. Thanks, Robin. Let's see, what's the next one? Yeah, a director is not acting in good faith if they have knowledge concerning a matter that would otherwise be unwarranted. So if you can't hide behind the business judgment, you need to tell the directors that you can't hide behind the business judgment rule if you know for a fact that there's information on something that is in direct contradiction of what the information that you have in front of you, okay? And a director can't be liable if they performed any of their actions in compliance with the business judgment. We just mentioned that. Thanks.
Scott, will you just speak? We had a question come in just to clarify the difference between an officer and a director for us.
Sure. There really is no difference when it comes to the business judgment rule or fiduciary duty. The director is obviously serving on the board. They were the ones that were voted in by the members to be on the board of directors to make the decisions for the corporations. And they can never be, you can never remove a director unless there's a recall. The owners would have to get a recall petition started to actually remove a director. An officer is those that would be the president, vice president, treasury secretary. A lot of times the officers are the directors, okay? When they're after the annual meeting, they have the meeting to determine who the officers are going to be. But it doesn't necessarily have to be a director. And a director, an officer sometimes is not a director. The directors may appoint a different officer to be the president or vice president. It's traditionally never done that way, but it is possible that you can be an officer and not a director. I don't know if that helps. Robin can probably expound on that a little bit, but traditionally we see the directors are all officers because they appoint themselves president, vice president, treasury, secretary. But sometimes we'll see a secretary or a treasurer that is not a director, and they'll have the protections of the business judgment rule and the insurance, and also, but they also owe fiduciary duty, even though an officer may not be a director. I hope that helps.
The only thing that, sorry, Scott, the only thing that I would add, because I see this as a common misconception, is sometimes I'll see associations say, well, we are electing the president this year, but that's not really the way it works. The members elect the directors, and so then you have a board of directors, and then typically within 10 days or so, there'll be, or sometimes right after the annual meeting, there will be an organizational meeting, and that's where the directors will then select officers from the director positions. So just, I see that as a common question that I get, so I just wanted to point that out as well.
Yep, that's good.
Perfect, thank you.
These are the cases that sort of guide us when we're looking at whether or not there's individual liability for a director. Again, I think what you should take away today is that the director doesn't really have any liability unless they engaged in fraud, self-dealing, or unjust enrichment. Okay, so some type of criminal conduct, some type of fraud and self-dealing. Again, we've talked about those situations. This top case basically held a director or directors and officers. Let's see. Okay, yeah, the directors were the officers, which is really common in B&J holding case. And they were personally liable because they didn't assess their own developer units. Okay, again, that's pretty obvious. Everybody has to pay assessments. Just because the developer may hold units, they have to pay assessments too, unless they went through the proper guarantee process in the condominium association. But all units pay assessments. So if you're not assessing a particular unit, obviously, then you're going to be held for self-dealing. Again, in the Munder case, which this is another example of a case, they found that there was no fraud self-dealing. And again, on this case, the only thing that happened is one of the directors or officers or the entire board failed to renew their fire insurance policy. And so obviously this guy Munder must have sued and said, well, I'm going to sue the individual directors. No, you can't. That's failing to do something, making a mistake for failing to renew the insurance. That's not fraud. That's not self-dealing. That's not unjust enrichment. That's just a mistake. So you're protected on the board when you make mistakes. There's insurance for that. We'll talk about that in a minute. But if you do something intentionally, you'll see then you are responsible. You have personal liability. So you see the difference in these two cases. Let's see, the next case, this Taylor case. This is another one where an officer was not held liable, even though there was some evidence of self-dealing. But the court's really going to have a high standard on this. Just because the plaintiff may introduce some evidence of self-dealing, the court's going to say, well, we really need to see it. Okay, just because you allege it, it's got to be proven. And here, they failed to enforce paid common expenses, failed to properly allocate association funds, properly designate expenses to the developer. It seems like this would be some sort of self-dealing, but this is a case, and this is actually a case out of the 5th DCA, which is the Central Florida East region over there by Daytona, extends all the way over. So this is good because this is a case that says this is a pretty high standard. There was some evidence of self-dealing here, but the court said, yeah, it's not enough. You've really got to show that they knew that what they were doing was wrong and that their hand was in the cookie jar when they were told to get their hand out of the cookie jar. So again, I caution associations sometimes when I hear certain directors, oh, I'm not running for the board. I don't want that type of liability. There is no liability unless you're intentionally doing something wrong. So I like that case. I don't like this other case because it sort of flies in the face of that case. These directors were found liable for civil theft and conversion because they took down an antenna, a cable antenna. And so the court did find that that was some form of self-dealing because they took it down, they didn't want to pay for it, and moved it to storage. I find this case to be an outlier and an oxymoron, and frankly, it's probably due to some bad lawyering. Because usually you can walk into the courtroom and say, prove it, judge. Prove where my folks have not relied on their own business judgment. Prove that they knew what they were doing was fraud, self-dealing, or unjust enrichment. So I really don't like this case, but it is out there. But thankfully, it's not in the Central Florida District or even in the North Florida District. Perlow v. Goldberg is another case right there. Again, this one stands for that principle. You're not held liable for your own negligent actions, making a mistake, failing to properly administer the insurance proceeds from Hurricane Andrew. Okay, that the board made their decision on probably how they wanted to distribute these proceeds. It's been a while since I read this case, but again, the takeaway, no fraud, no self-dealing, no unjust enrichment. So you're good. Another case, Sonny Boy worked on this case back in the day. Thanks a lot. This was one where the owner tried to say, well, the statute says a developer-appointed director really shouldn't be liable here. Or a director can be liable, but not a developer-appointed director. And the court said, no, all directors are liable. Even if you're a developer-appointed director, you would still have liability. In my eyes, there should be a little bit of a higher standard because the developer should have a little bit more information and know the statute a little bit better than just your regular common unit owner that really doesn't understand the Condominium Act. So again, even developer-appointed directors can be liable as well. Got another case here. This one is, again, it's another one where they got off the hook because the 4-year statute of limitations had already run. But the court here was pretty tough and said the directors required that even if there's an allegation of fraud, self-dealing, you're required to show that there was not. And I don't like that. That kind of annoys me. I think the 4th District here is being a little tough, saying that the burden is on the unit owners to show that it's not. I think the burden should be on the plaintiff to show that there was fraud, self-dealing, and unjust enrichment. So let's not get wrapped up in the 4th District too much. Let's move on from that. I don't really like that. Let me talk about insurance real quick. I just want to respect some of the time and not eat up too much time. Oh, you're up, Robin, on indemnification. I'm sorry, go ahead.
No, I won't be very long with indemnification. But I did want to address one of the questions that we got ahead of time. One of the attendees, hopefully she might be on today, Dina asked whether or not there should be a code of conduct for board members. And while the statutes and your governing documents will typically address certain behaviors of the board members, sometimes it is helpful to have a board of conduct. I do have some associations who have asked me to prepare a code of conduct for the owners and for the directors, and becoming a director that they are required to sign the code of conduct so they know that what they are required to do and what they shouldn't do. Again, I don't know if it gets you any greater protection, but I do think it's helpful so each director knows what they are entering into when they run for the board.
Yeah,
So,
I agree from a management standpoint. If I can just add there, Robin, part of our board orientations that we do is we talk about, these things and having everybody in the same room at the same time, hear the same message and see the same sheet of paper of what the expectation is. If you have that discussion up front every year when you get new people on the board, it does make those potential tough conversations that come up with different situations. It makes them easier when you can kind of refer back to, remember the discussion about what our conduct we all agreed was going to be.
great. That's good to hear. Thank you. So Scott did a great job of telling you, about the business judgment rule, which is wonderful for associations. The fact is, though, that anybody can go down to the courthouse and file a lawsuit and name any of the directors. And so that's why you have insurance, which Scott's going to talk about in a little bit. But it's also helpful to make sure that you have an indemnification provision in your governing documents, and there is already one in the statute. So what indemnification is basically stating that if any of the officers, directors, or committee members are individually sued, that the association as the corporate entity would come in and basically provide a defense for that individual person, or would potentially pay the claim in the event a liability is found. You do not see the indemnification provision in either 718 or in 720, but you do see it actually in 607, which is the For-Profit Corporation Act. But when you look at 617, it basically says, you go to the For-Profit Corporation Act. And it basically says that a corporation it has the ability of indemnifying any current or former officer and director, because, sometimes things happen after you go off the board. As long as the person acted in good faith in the best interest of the association, and even if there's a criminal action, as long as there is a belief that there is no unlawful conduct. The statute goes on to say that the officer will be indemnified, one, against expenses actually incurred by the director or officer, for legal defenses, to provide a defense for that officer or director, and that unless there's a court ruling relative to the indemnification, the association can only statutorily, again, indemnify a director as long as that director has met the standard of care, which is making sure that you comply with the best interests of the community and that you don't engage in fraud, self-dealing, as Scott just discussed. Now, in addition to the statutory indemnification, oh, I'm sorry, there's one more. So the determination on whether or not there should be statutory indemnification is either a majority of the disinterested directors will vote for it, a majority of the disinterested committee members will vote for it, your council has stated it, or a majority vote of the unit owners who are not involved vote in favor of it. But again, in addition to the statutory indemnification, you can actually provide in your, this should be actually contract, not contact indemnification, sorry about that, contractual indemnification, which would arise from anything in your declaration, articles, or bylaws. Now, there are good provisions and there's not very good provisions. We have a sample of a good provision that we like to put in the governing documents that we draft for our clients. It's very detailed. It, as you can see, it covers officers, directors, and don't forget those committee members, because I did just recently have a case where individual committee members were also sued. And so we had to look at the governing documents to make sure that their documents also provided indemnification for the committee members. Luckily, theirs did, so we were good. But you do want to make sure you have that in there for your committee members that are doing work for the association. This goes to explain the indemnity as broad as we can within the statute, as well as specifically stating that the defense will be covered. It also states that in the event there's any certain costs that the officer, director, or committee member is going to incur, that you will be able to, the association will actually advance those costs to them. We have a miscellaneous that says that, just to let you know, while we've tried to put everything in here, in case we missed anything, you can certainly broaden this provision, by any other bylaw agreement voted the members. And insurance, of course, we want to make sure that, as Scott is going to discuss next, that the association has the power to purchase insurance to cover your officers and directors and committee members and any agent and employees. So in the event that they are sued individually, that the insurance can appoint defense counsel and they can come in and defend the individuals as well as the association, depending on the case. Now, Scott, you could talk about insurance.
Okay. I love insurance, and I also hate insurance companies because you got to have insurance. I mean, because the fact of the matter is, you don't want to be sending a lawsuit over to me, having me defend it for 3 years. It's going to cost a fortune. So when you send it over to us, the first thing we're going to do is try to send it to your insurance carrier, and they're going to come in and give you a defense and indemnify you for the X, because that's what it's there for. I love, sometimes I get a call from a manager or a president, and they'll say, "This is crazy. This guy is trying to sue us for slipping outside of his unit. We know for a fact he didn't injure himself. We know this is all bogus." I agree with you. It probably is, okay? We realize you didn't do anything wrong with the dog bite. We realize the slip and fall is probably not your problem. But again, they're going to go out, they're going to hire one of these PI, personal injury law firms, and they're going to get some type of settlement because they're going to drag it out. And I don't want you not to report the claim to your carrier and then find out that a judge doesn't like it and says, "Oh, we're going to hit you a judgment against you for $1 million because you didn't want to send it over to your carrier." Now you spent $100 grand on legal fees, and now you get a judgment for $1 million, all because you thought the claim was bogus. And even though the court might have thought the claim was bogus, there was enough there where the court said, "We're going to allow it to go forward." And the jury felt some sympathy for him because the lawyer put on this big dog and pony show about how the guy's never going to walk again, and it's all the association's fault. So you just got to turn it over to these insurance That's why you have insurance. I know you're saying right now, well, the policy is going to go up if we file a claim. Guess what? The policy is going to go up every year anyways. It always does. There's no way around it. And that's why you have insurance, to protect yourself. Liability insurance, that's for your slip and falls, okay? That's for someone that's saying they got bit by a dog, the neighbor's unit owner, and they're going to sue the association. It's not your fault, but guess what? They're going to say, well, you had a duty to protect. You knew or should have known the dog was bad, and you're just going to be one of the named defendants. The Morgan & Morgans out there are going to sue any insurance they can find that it's anywhere in the zone of liability, and just trust me, it's better to just turn it over to the carrier. So that's your liability. Your property insurance, that's for, when you have a leak. That's when you have a casualty event, an occurrence without fault, fire, hurricane, any one of those. Now, the large disaster claims, please, when your insurance company comes out after a hurricane and says, no, you don't meet your deductible. Okay, and you're like, well, we got a ton of damage here from this hurricane. Call me up. I'll get you in touch with a private adjuster, someone that can work for you hard to get the money you deserve. Okay, so you got your property insurance. That's for your casualties. That's to build your property back. Fidelity bonding, that's if you have like a rogue. Oh gosh, let's just say you hired, you're a manager and you hired some employee to come out there and clear some brush one day, or stack some boxes, and they ended up digging into the cookie jar and stealing money. If there's any employee theft, that's what a fidelity bond does. It covers that. An umbrella policy, some associations have it. It's not, I've always recommended it. It's just an added layer of protection, that in the event that one of these insurance, the liability or the property or the D&O doesn't have proper limits, you have another liability on top of that. It's not automatic. It's not necessary. It's just like a belt and suspenders additional coverage. It's an umbrella that protects over and above the other insurance that wouldn't pay. But it's not required. If you just can't afford it and it's too expensive, don't do it. Your general liability and your D&O should cover you. And then the D&O, we'll talk about that more. Again, that's when your directors and officers coverage kicks in if you're sued individually. If these directors and officers are sued individually, that D&O policy will cover them. What we do a lot of times is we'll put the association's getting sued, and then 5 directors are getting sued, again, by some crazy unit owner, right? And what we do is we put the liability on notice and the D&O, because D&O will say, oh, we have an exclusion. That really doesn't apply to the situation. Well, we send it to the liability carrier. Maybe they pick up coverage on that. Again, we'll talk about that in a minute. Workman's comp, again, it's good to have that, especially if the association has employees. Boiler and machinery, you don't need that, just scratch that. Business loss is great. If you have that, you may have that built into your liability policy as an additional rider. And that is good, but they don't pay many claims. A lot of people try to make a COVID claim on business loss, and they denied all those. So I don't want to talk much about business loss. If you have it, it's good. It's just rarely invoked. Let's see what the first, the directors and officers is what I want to talk about, because that's sort of the focus today. I don't want to see any of these directors and officers have liability, and that's why the D&O policy protects them. So again, if somebody's claiming breach of fiduciary duty against a director or an officer because they made a mistake, you send it to the D&O carrier. Instead of paying me, we send it over to the D&O and say, hey, give them a free lawyer to defend this bogus lawsuit. All right, the association doesn't want to pay me $300 an hour for a lawsuit that they have insurance for. Okay, and then a lot of times we'll monitor it and just kind of push the insurance lawyer a little bit to settle the case. But that's much better than having us defend it on a daily basis when you already have insurance for that. A lot of times the insurance carrier will hire us so that you can get our legal fees paid by the insurance carrier. I'll talk about that. It doesn't cover, the D&O doesn't cover bodily injury or property damage. Again, bodily injury would be covered by a liability policy, property damage covered by the property policy. Some D&Os prohibit as an exclusion if you're paying a director or an officer. So if you have an association that allows a director or an officer to be paid, I don't really like that, first of all. Second of all, though, if you do have that, you may want to check your policy, ask your insurance agent if there's an exclusion in the policy that prohibits it. All right, thanks. Let's see what else we got. You know, you can ask your agent about policy limits and coverage, but a lot of times it is what it is. You can ask them how much more it would be to get certain coverage. Like if you only have $1 million, maybe ask, well, what does $3 million get us? How much more does that going to cost you? But generally, if you have $1 million, you're generally covered most of the time. So you want to find out what are your policy limits. We can look at that for you, but they're pretty, they should be right on the first declaration page. And what are the exclusions? Again, there's exclusions and then there's exceptions to the exclusions in these policies. They're written by lawyers. Unfortunately, they're tough to read. So you can ask your agent, hey, are there any exclusions that in the policy that really hurt us? Sometimes there are. And the agent should be able to tell you that. Does the policy provide for a defense where the policy will not actually cover the loss? So the policy may say, well, we're not going to cover that. We have an exclusion for that. Okay, fine. But you still have to defend because the allegations in the complaint arguably would give coverage in other aspects. Sometimes what I'll see is an insurance company deny the lawsuit coverage, the D&O coverage. And then I'll call up the plaintiff's lawyer and I'll say, hey, I don't know what your goal here is, but if your goal is to try to get money here, well, association's not going to pay you. But if you think the insurance company is, you may want to replete your complaint because right now there's no coverage. And I wouldn't put that in an email, but I'll put it off the record to protect the association so they can get some insurance policy coverage there to come in and defend this claim. And I have that happen right now where an association's directors have been sued and the insurance company is saying there is no coverage for what they're being sued for. They're being sued for, you know, changing the cable contract. That's a breach of contract. That's not a D&O coverage issue. Now, I think it is, but I said, well, even though there's no indemnification, maybe you still have to defend them under the policy. And they said, yeah, we get that. And they're defending by paying my legal fees. After a while, they're going to get sick of that and give me a little authority to throw a little bit of money to make this plaintiff go away. So even a defense is big. Let's see what else we got here. Another question to ask your agent. Does the policy only cover officers or directors? Again, Robin touched on this. Your D&O policy, you should make sure that you're to ask your agent, does this officer and director policy, does it also cover the committee members or volunteers or maybe, you know, the management company? It should cover them. So make sure that your agent flushes that out for you. When does the association have to report a claim? Early and often. That's my answer to that. If you know that there's a dog bite, a slip and fall, if you have a lawsuit, we need to report that claim. Now, knock on wood, I'm pretty good about even on late claims a year later, you know, I find a different policy that we can report to, maybe an older policy that's in play, and I'm pretty good about getting coverage for you so you don't have to pay for this claim. But if you know about a claim, and I ask you, I'm going to ask you in the first board meeting when we discuss this lawsuit, hey, send me your insurance policies. Let's make a claim. If you say, no, we're not doing that right now. Let's see if you can get it kicked. You know, try to file a motion to dismiss, Scott. Try to get it out of there. Okay, fine. But if I lose that motion to dismiss and it still goes, some of these policies, Lloyd's of London, for example, they may say, no, we're not covering it. You decided to defend it on your own. I don't want to be in that situation. I'm pretty good at pushing back, but you have a claim. Let's get it to the carrier early and often. Let's see what else we got here. If a party covered by the policy is sued, can the association use its own lawyer? Yeah, I hope so. The first thing I put my demand to the insurance company is I say pursuant to certain case law, and I use like Jedi mind tricks and lawyer legal terms on them. The association wants me and Robin to defend them in this lawsuit. And as a matter of fact, we're both board certified lawyers. As a matter of fact, we've been doing community association law for centuries, and there's nobody else out there that's more qualified to defend them. We know about the history of the case. We know that it's bogus. We're better equipped to get it dismissed than any other lawyer you're going to go out there and try to hire. So why don't you just appoint us pursuant to case law? Some of them do. Some of them will come back and say, well, I'm not paying you, $275 an hour. Will you do it for $225 an hour? I'll lower my rate. Yeah, for the association on a lawsuit like that, if the insurance company's paying, I will lower my rate because I want to be able to protect you. I know how to work against some of these plaintiff lawyers. I don't want to be just some, second year associate that's assigned to a file for an insurance company, and they say, we need to settle, we need to settle. No, you don't. Do your job and take a deposition and push back on the plaintiff and tell them to drop their case. So that's what we try to do. We're not always assigned as the insurance defense lawyer. That's fine. As long as you get a free lawyer, that's all I really care about, right? Either they're paying me or they're going to pay someone else. And then usually Robin will just monitor the case to make sure that lawyer is doing their job. I better get going here. Yeah, some of the exclusions could be discrimination, self-dealing. Again, a lot of insurance companies will say, hey, they're saying you had self-dealing, you had unjust enrichment, you committed fraud. We're not going to give you an insurance defense for that. Yes, you are. You're going to defend it. Now, you may not pay the claim because it's self-dealing, but you're going to defend it. So a lot of times they'll still defend. But if you got a director out there that's engaging in active discrimination, of course, the insurance company is saying we don't cover that. All right, let's see what else we got. We don't need to talk about these. Let's move on to the next one. Thanks. Oh, go ahead, Robin.
Thank you. One thing that I wanted to touch on before we move off of insurance is we did have a couple of questions about COVID. First of all, we do have, you should go to the Becker website, and we do have several webinars already. I think Castle has several webinars, or we've done joint webinars about COVID. So that's a whole hour, 2 hours for you to do that. But one thing I did want to say is I do know that some of my associations did obtain, first of all, there's typically not going to be insurance coverage for exposure to COVID and other viruses. So there is an insurance company out there that has said, well, we'll provide at least a defense. As Scott was explaining to you, a lot of times the defense costs are just a lot, and that's going to help you just to have a defense. So I did want to let you know, I don't know anything about it. I'm not necessarily endorsing it, but I do have some clients who have elected to purchase defense coverage for COVID claims and other claims, but it is certainly just for defense. The other thing that I wanted to say is that just yesterday, there is a bill that's being introduced in the Florida legislature that is aimed to protect businesses, including community associations, from liability for exposure to COVID, other bacteria, viruses, and contagions. So hopefully that will go through. You do have to follow your CDC guidelines about cleaning in order to be able to take advantage of that immunity from liability. But it has been filed with the legislature, so hopefully that will go through this year. So the next thing that we're going to do is go through a few of the top 10 mistakes that associations make. This is not necessarily meaning that these are items that will be a breach of fiduciary duty or expose you to liability. It might expose the association to some liability or a complaint with the division, but they're not anything really huge, but they're minor mistakes that could expose the association to liability. So we're just going to go over a few of them. First of all, you are required, you probably noticed that you are required to post notice of board meetings. But what you may not know is that you're actually supposed to adopt a rule as to where on the property you're going to post the meetings. I rarely see a rule being adopted. Instead, the association just posts the meetings. So you really need to adopt a rule as to where the notices of the board meetings will be posted.
Robin, can you just speak to the committee meetings as well, what your opinion is on that? We get a lot of questions about, do I have to post my committee meetings with that same notice?
So there are some committee meetings that are required to be posted just like a board meeting. So any committee that is going to be charged with deciding the budget, so your budget committee, for approving the budget, are required to be posted and open to the members just like a board meeting. The other committees that is open to members and has to be posted like the board meetings are architectural control meetings. So if you have an architectural committee that's going to be making final decisions regarding architectural matters, those have to be noticed and open just like your board meetings. Those are really the main two that's in the statute that are treated like board meetings. Other committee meetings, social committees, even your fining committee or your covenants committee are not required by statute to be noticed like your board meetings. That's not to say that you probably might want to, especially if you want people to come to your social committee meetings or any other type of committees that you might have in the community. So you definitely can if you want to. There's just not a statutory obligation to do so. Good question.
Thank you.
Official records is another one. There may be some changes in the law about that this year because it appears to be the #1 complaint filed with the Division of Condominiums. Please remember, when you receive an official records request, it only has to be in writing unless you've adopted rules otherwise. So if you get an email, you do have to provide access to official records. Even during COVID, you do need to do it within 10 working days. On the screen is the quote from the Condominium Act. However, the HOA statute says the same thing. You have 10 working days to provide access to those records. You can choose to email them if you want to, but you don't need to. You just have to make them available, meaning have them schedule an appointment to come into your office to look at them. Again, the association has no obligation to mail or email the records. You just have to make them available. If you do not make them available, there are monetary penalties. It's not automatic. I have owners that say, you didn't provide these records to me, pay me some money. That's not the way it works. You actually have to go to court. An owner would have to go to court in order to make you pay that amount of money. And you can adopt reasonable rules. There is a whole bunch of arbitration cases that tell you what is a reasonable rule. So I do highly suggest that if you're going to adopt rules regarding official records access, that you consult an attorney so you adopt something that the Division of Condominiums will think is reasonable. While you don't have that regulation in the HOA context, you may still want to rely on the condo decisions in the HOA context as well. Certified mail inquiries. This is only in the condominium setting. You don't have the equal in the 720. But basically, this is when an owner actually sends a question. It has to be a question to you in writing via certified mail. You have to provide a response within 30 days, or you can get an extension if you have to send the matter to your legal counselor to render an opinion. Again, if you fail to provide it, the penalty, if you fail to provide an answer to the certified inquiry, the penalty is basically if that unit owner sues the association based upon the question that they asked, then even if the association wins, they're not going to get their money for prevailing party attorney's fees. So it is a good idea to answer those certified inquiries. Conducting association votes. Again, you need to have your votes at a board meeting. You're not supposed to have at an open notice board meeting. You need to have votes at any members meeting if it's something that the members have to vote upon. You need to make sure that your notices are properly mailed and that you have an affidavit signed saying that you properly mailed the notices to the members. In most circumstances, you are going to be allowed to, the members are going to be allowed to vote by proxy, not the directors. The directors cannot vote by proxy. But the members at any member meeting can vote by proxy. There are certain instances as to what type of proxy you have to use. A limited proxy is the proxy that actually has the question on there, and it tells the proxy holder how to vote. So it'll be, I direct my proxy holder to vote and it'll have the question, and it'll have yes or no. In the condominium context, almost everything is going to require a limited proxy. If you're voting on reserves, if you're voting on any amendments, if you're voting on changing the annual financial statement requirement, material alterations, you're going to need a limited proxy. In the HOA context, it depends on what your governing documents state. There are a lot of times that you use a general proxy. You will also use general proxies to be able to certify a quorum. So if you just need individuals to return the proxy to make sure you reach your quorum, then you can use a general proxy for that. Again, I mentioned on the last slide what you use your limited proxies for. Material alterations, again, this is in the Condominium Act, not in the HOA. If you are going to materially alter your common elements, change the way they look, their function, their use, you are going to typically need a vote of the members. If your declaration doesn't say so, it's going to be 75%. And you do have to do it before you make the alteration. So if you're thinking about changing anything, talk to your lawyer about what you need to do. Special assessments, there is a specific way to levy special assessments. You do need to provide 14-day notice, explain what the special assessment is going to be for. If you do not do it right, then it can be contested and you may not be able to collect it. So make sure you're levying your special assessments right. Again, this just goes through the way you are supposed to notice the special assessments. Again, it's 14-day notice, and you have to say that special assessments are going to be considered and what the special assessment is going to be for. Hurricane shutter specifications, again, another common one that I see. You are required to, in the condominium, again, not in the HOA, you are required to have hurricane shutter specifications. If you do not have specifications, then an owner who wants to put up shutters can put up whatever they want. However, because you are required to have the shutter specifications, if you do, and there are companies that will come out to your property and tell you and give you recommendations as to shutter specifications, if you have them, then you can make the unit owner comply and only install the shutters in compliance with your shutter specifications. So if you haven't done that, reach out to your attorney so you can get that done. Okay, back to you, Scott.
Yeah, I think, I talk too much, and I think we may be running out of time. The next few slides, or the remaining slides, I can sum up just without even having to run through the slides, because I'm pretty passionate about it. It's contracts. A lot of times litigation with what we do is because of a breach of contract, a contract that went bad. We get a lot of calls after the fact that, hey, can you help us with this construction matter? The contractor's gone rogue. Can you help us get out of this elevator contract? Can you help us get out of this landscaping contract? The first thing I ask is, did we review the contract? Did I provide an addendum for it? Well, no, the board didn't want to pay to have you review the contract. Some of these contracts, an association will spend $93,000 repainting, 17 buildings, but they won't spend another $700 for me to put an addendum on the contract. And it's hard for me to put the toothpaste back into the tube when I didn't put in all these special provisions through an addendum or changes to the contract. I mean, is there an indemnification provision on the contract? What about a warranty? I could have asked for an extended warranty. By the way, do you realize this roofing contract you signed, you now have to go to arbitration in Pittsburgh? Okay, if I was handling it, I could have got court litigation here in St. Johns County. Insurance, all these contracts, the association, I have a huge insurance provision that I add in, saying the association should be a named insurer, an additional insured on these contracts. So I would just caution you on a lot of your contracts that the board is signing, just advise them, protect yourself. Hey, maybe you want to shoot this over to Robin and have her look at it. Scott's board certified in construction law in Florida. Why don't you have Scott look over this roofing contract and maybe give us an addendum to it? We can't help you if you don't come to us first. I mean, a lot of times I'll see a painting contract, and the painting contract, I'm like, why do you have a painting contract? Well, because it's 7 years and we have to repaint the buildings. Okay, well, all the photos that you sent me show giant cracks in the stucco. They show leaking coming from the windows. They show roof staining coming from roof leaks. Do you realize you're still within the 10-year window that you can bring a construction defect action against the original developer and all the original contractors? We do those construction defect actions on a full contingency. It doesn't cost the association a dime, and yet you're painting over bad stucco that's still going to continue to crack and allow moisture and water to get in the walls and behind the new siding that's put in. I see a lot on buildings is there's moisture behind there. Let's at least attempt to try to get you millions of dollars potentially to fix all of these problems, because you've got one life in the history of your building to go after the people that are responsible. That's 10 years. You got 10 years. You got 4 years from when you should have known. But if it's a latent defect, we can sue still up to 10 years. After that, you got to turn around to your members and pass a special assessment. And that's going to be a hard one to explain, is when somebody says, well, did you ever go after the builder? Did you ever go after the developer? Well, no, we really didn't want to do that. I mean, okay, well, you could have got free money there to fix these problems. So yeah, that's my plug for construction. At least have us interview for the association to tell them what their options are in a construction defect action. And there's other companies out there that do the same thing, other firms. I would have your board interview at least 2 or 3 law firms to talk about what they can do for you on construction defects. But yeah, on these contracts, especially construction contracts, have us look those over. Let me give you an addendum. And you can even tell me your budget. Hey, the board doesn't want to spend more than, the $800 here reviewing this. Well, here's another thing. One thing I'm going to say is, don't spend the money on me. At least have an engineer sign off on the pay applications for all of the roofs that are being done. I mean, there's 2 protections you can have: a really good contract and a really good engineer. I would rather you have an engineer before you have a good contract, because the engineer is going to be able to go up to the contractor and say, you see all that tile you just put in? None of it's done according to code. I'm not going to authorize the association to pay you for this building until you go back and do it all again. So a lot of times the board's like, well, I look like a hero because we had a $200,000 budget for all these re-roofing and I got it done for $175,000. I'm like, okay, you're not really a hero if they're done incorrectly, because you wouldn't spend an extra $5,000 to go out and hire an engineer to overlook it, or spend $800 for me to do an addendum to the contract. Also, on these construction contracts, you may get something called a notice to owner from a subcontractor. Again, that's important. I see on the slide here, notice of commencement, that has to be recorded by the contractor on a big project before they start. But these notices to owner, that's the subcontractor saying, hey, you don't know me, but I was hired by your contractor to do some of this work. And if he doesn't pay me, then I'm going to put a lien against your property. So make sure when you go ahead and pay the contractor, you get those lien releases and lien waivers from all those subcontractors. Again, I'm happy to help you with all that. Construction is very passionate to me, so as you can tell. So call me anytime. I'm easy to find. Thank you for your time today very much. This was great.
That's great, Scott. Thank you. I just wanted to add on to there from a management perspective. We always recommend, our best practice is for the board to send the contracts, to the attorney before they get signed. And we get the same pushback. Can't the manager just do it? Castle, can't you just do it? And I couldn't agree more with what you said. We'll do all the negotiating up front, but it has got to go to the attorney. That is for sure our best practice. We had a question that came in, and I wanted to make sure we touched on it before we ended off. And it says, our president signed a contract for $20,000 for installing pavers without a board vote. The same officer signed a letter of engagement without board vote. Is this person personally liable? And there was another question that came in beforehand that was very similar. So I don't know if each of you would like to touch on that, but if you could kind of give us some thoughts.
I could just jump in real quick there. The first thing I'm going to say is that contract is binding. You're not going to be able to get out of it. The paver company, if they knew that this was the president of the association, the president held himself out as having authority to sign that contract, you're probably not going to be able to get around it. And I don't think the president would be liable there, personal liability, if the president really thought he had the authority to go forward and sign that contract. But if the president knows that the board had to approve that and he went ahead and did it anyways, then I would say that's self-dealing, or that's willful, wanton, reckless conduct, where I think a case would go forward for personal liability. But again, a lot of these presidents and officers just think, well, I didn't know. I guess we just ratify it later? Yeah, you could do that. But if you know for a fact that the board said we want to review these contracts before it's signed, and you go ahead and sign it, well, now you're engaging. You probably have some personal liability, and I believe the insurance company is probably going to defend, but they may question indemnification. So let's not get into that situation. And the answer is yes, or it could be no. But that's a bad situation there. Yeah, there's potential liability.
The only thing that I want to add is that Scott hit it up right on. But I do want to remind all directors that you need to make sure that there are times when I get associations where there is a strong president that is running basically running the board. And you have to remember, if one of you is responsible, you need to make sure that you know what's going on. Now, there are times that you're not going to know what's going on. The president is doing things, not telling anybody. There's no way for you to know. But you have to remember that you are a director. You do need to put input, and you need to make sure you know what's going on. So if you do have a situation where you do have a strong person that's running the board, please make sure that you're aware of what's going on and become aware of what's going on. So thank you.
Great. And then I'm going to merge two questions together, if that's okay, for the sake of time, because we have gone a few minutes over. The question is, what actions can be taken against board members who go against the board to create problems, and board members who share confidential board information, outside of the board?
So I can take that quickly, Scott, and then you can add anything if you want. So a lot of times what I do is the first thing that I do is I say, well, one, have you had any one-on-one conversation? Let's reach out to this person. Have you tried to talk to them outside of a board meeting context? And if that doesn't work, then sometimes I've had to send actual cease and desist letters to directors to explain to them, remind them they have a fiduciary duty, remind them that they cannot disclose confidential information, and that if they do so, that they can be held liable for breaching their fiduciary duty. I have some directors that sometimes start going out there and telling the vendors what they can and cannot do, and so I have to tell them, you can't do that. You can't interfere with business relationships. So there are times. The other thing that sometimes I recommend is if the person is an officer on the board, while you, as Scott mentioned earlier, you cannot remove directors, only members can remove directors, but the board can remove an officer. So if you have an officer that is not behaving, then you can say, at the next board meeting, I move to remove so-and-so as the vice president of the association, and the board can vote on that and remove the person from their officer position. So those are a few different things that I recommend to our clients to handle rogue board members, basically.
Yeah, that's good. I have nothing to add there. I do see a question. Is there personal liability for the board keeping our amenities closed during COVID? No. There's a simple answer to that. I mean, that they believe they're acting in the best interest to protect the members. That's the furthest thing away from personal liability.
Okay, and I think the last one that we had that I don't think we've addressed yet is the best way for board members to have discussions.
In meetings.
Yep. Now the law does
in a legally posted meeting.
In a legally open posted board meeting. The law does allow for email communications, but that's not supposed to be a substitute for an open and noticed board meeting for the members to attend. It is simply for the board to be able to have small email communications and not be considered a meeting. Like, are we going to put this on the agenda? What do you think about this? How are we going to handle this? But it's not supposed to be a way where you go to the meeting and then you just vote on everything and it's a rubber stamp. That's not the purpose of it. So you can communicate by email. You cannot vote by email. All discussions should be had at open notice board meetings.
Fantastic. Well, Robin and Scott, thank you so much. You guys are always a wealth of knowledge and so generous with your time. We really appreciate it. And for everyone who stuck with us for the hour, you certainly are welcome to reach out to us at info@castlegroup.com or reach out directly to one of these fabulous attorneys. If you send anything to us at Castle Group that needs to go to Robin or Scott, we'll make sure we pass it along to them. Thank you so much.
Thanks,
Enjoy
Joanna.
your Friday Eve, and we'll talk to you guys again.